My friends, I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plains of the internet before we go ahead and get started. Got to make sure those tubes are connected over on the Rumbles and the locals and the YouTubes and everywhere else. And I think they're connected and alive. That's tremendous. Let's go ahead and get started then, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about the 14th Amendment. That's right. This is an interesting issue, and, I know some people are kind of poo-pooing this whole thing, but I think there's a real concern that this may cause some ruckus before the Supreme Court has an opportunity to settle it, and if and when they settle it. So we're going to go through this because we've already talked here previously about this lawsuit taking place out of Colorado, filed by this organization called CREW. You can see here the organization is the Colorado Republican State Committee. Well, we'll see. There's a bunch of people being sued, so we'll go through it. Point is, Donald Trump filed a response, and this came from an organization that's trying to remove Donald Trump. And so this is Trump's motion to dismiss their lawsuit. And so I see here the CREW people may actually, no, I think we'll go through it. I think the CREW people are the petitioners, so we'll go through that. And it's, somewhat substantive, about 26 pages, and they give us a lot of history that explains Trump's argument, which is that the 14th Amendment does not apply to Donald Trump. He was the president, and they actually give us a very nice breakdown of the argument. They say that one group, the people who the 14th Amendment does apply to, they swear an oath to the Constitution. I swear to uphold the Constitution. But that's not what the president does. The president swears a different magical phrase, which we'll talk about. And that magical phrase is not the same phrase as what we see in the 14th Amendment. That exonerates the president from the jurisdiction of the 14th Amendment. So we'll go through all of it and see what is inside and do some heavy lifting on that one. And then we're going to see what happened with the senator. This is Bob Menendez, and he's from New Jersey. And he's the same guy who replaced Joe Biden on the Foreign Committee, the Foreign Affairs Committee in the Senate. And he got another criminal charge today. A superseding indictment was dropped, and this is alleging FARA violations, so Foreign Agents Registration Act. Many of the same charges that people are wondering why Hunter has not been charged with, or Joe Biden has been charged with. And we talked here yesterday about the thousands of emails that Joe Biden's vice presidential office sent back and forth with the rest of his family, including people like Hunter and James, his brother. And we also saw that there was a cover-up well underway. Right as Joe Biden got elected, they were just cleaning up the crime scene at the Penn Biden Center to delete all the classified documents and get rid of those. And so, all of, I think what that was is covering up this type of stuff to make sure that Joe wasn't under any type of threat as he's reigning over the country, wrecking everything. So we'll go through this. We have the actual superseding indictment, and we read through the original indictment when he was originally indicted. So we'll just hit the highlights on this one and see where the FARA violations come into play. We'll also see what the White House has to say about this, because they are not talking too much about Menendez. But I came across this interesting clip. There's a lot going on in the world, of course, and they're also, they're sort of saying that you can't attack Joe Biden right now because we should all be unified and focused on the attack on Israel and the response. And it's a strange thing that's happening. So we'll go through that clip. Republicans are saying it. And some people in the Senate are calling for Menendez to get the boot. And so Fetterman is one of them. And then there's this interesting clip of Fetterman where he's saying that, yeah, we're not sending our best and brightest over to Washington. So we've got two segments today, a little bit lighter on the news today. I know there's a lot of attention on the other world affairs right now, and there are a lot of those. And so we are praying for everybody, who's affected by what's happening there, and we're praying for some resolution, but we know that there's a long road ahead until we get there. So we have been talking about that and more. We've been really digging into the war and exactly what's going on in our membership and our mornings. And we had a great conversation today. It's a very complicated issue. And so it's a difficult thing to discuss. And so we're trying to do our best at watchingthewatchers.locals.com, where we can engage as on a more friendly plane, as a community, and try not to kill each other in the meantime. And so if you want to join us as we debate these issues and more, head on over to watchingthewatchers.locals.com. We do member-only shows in the morning, and we do Saturday streams, and we do a lot of other fun things. And so come check us out, watchingthewatchers.locals.com in the house. We also appreciate our YouTube members, get a lot of the same things. The only thing for our YouTube members is we ask that you join us on Telegram for our members-only after party. So when the show here ends, we hang out and debrief all the things that we talked about. So either join us on Telegram or come on over to Locals and join us there. We've also got our website, robertgovea.com. You can click over here, sign up for our daily newsletter. So all this stuff will just get delivered right to your inbox. On our website, we've got this reports section, so you can navigate the reports. And in case you miss something, or you don't want to navigate to YouTube, or you just want to read a summary of what the video discussed, we turn them all into articles right here, so you can get just a nice summary on what was literally discussed in the video. And we're working on getting PDFs as well. So the PDFs from the show will be put in here so that you can get all the PDFs as well, just right accessible on the website. So this is what your support goes to build, right? We're actually building out the team and building all this stuff out. And so we're grateful for our members. We try to really deliver some features so that we can all stay plugged in and connected. Speaking of staying connected, this weekend we've got the Eric's House 2023 fundraiser. ericshouse.org is an organization dedicated to helping good people who have lost a loved one due to suicide, substance abuse, overdose, or a tragic death. And they have been helping just, hundreds, if not thousands of people now from all over the country, all over the world, after they've lost somebody due to one of those things. Like our family lost my younger brother. We were without guidance on how to cope and how to survive that. And so Eric's House is dedicated to connecting people and making sure that they have the resources and the support that they need. This weekend, I'm going to be hosting, along with the rest of the Eric's House team, I'm going to be emceeing the whole thing. On Saturday, go to ericshouse.org or go to the Eric's House YouTube channel on YouTube. 4-hour special event, fundraiser event. And if you want to support us, go to watchersupport.com, and that's going to forward you over to the dono page, which looks just like this. And man, we're making some good donos here. And so after the show, we're going to come back and say thank you to everybody who is donating here to support the work that goes on. And it's all a 501c3. It's all nonprofit stuff. So check it out. ericshouse.org or watchersupport.com. All right. And so maybe we can pin that up. Yes. Thank you, V. We'll pin that in the chat. Pin that in the chat over on Rumble. Thanks for the reminder. All right. And so, man, yeah, see, locals. Yeah, Ravika says, I lost my younger brother to suicide. Me too, brother. So there's a lot of us out there. You're not alone, right? It is an epidemic in this country. A lot of people are in a bad way right now. So we're out there trying to support each other. Eric's House is where to do it if you need it. So, all right. And again, right, if you can't make a donation, that's okay. If you need help, like if you're in this situation, okay, go to ericshouse.org, right? That's what they're there for. So they're ready and standing by as well. And they have the best people over there. Shout out to Maddie. Shout out to Maddie. All right. Now, let's get into it. Donald Trump and his defense come out swinging in the Colorado lawsuit. They're trying to throw him off the ballot in that state and many other states. And Trump's defense came out and they said, hey, you can't do that under the 14th Amendment. And the reason is that the 14th Amendment, they say, does not apply to the president. And so this is a pretty substantive lawsuit. We've talked about other attempts and efforts by people to keep Trump off the ballot, and many of them have been laughable, right? We had the one out of Florida. We're like, oh gosh, this guy. So we filed it. It got dismissed pretty rapidly. But this one is moving forward, right? This one's moving along, and they're making some pretty interesting arguments. And you don't need a lot to happen here. You just need one judge or one secretary of state to hit that trigger button, and then boom, like dominoes, all of the lefty secretaries of states, all the lefty courts will all just start falling like dominoes, and we could be in a real serious problem here. So Trump is now in a real substantive response explaining exactly why the 14th Amendment, the insurrection clause, doesn't apply to him. And so let's get right into it. You can see it is drafted here. And again, We are in Colorado, so we're going to be bouncing around the country, but the arguments are the same because they all refer back up to the 14th Amendment of the United States Constitution. So each one of these is like a shot on goal. They're just trying. Let's try Colorado. Let's try Florida. Let's try Nevada. Let's see where else we can go to try to keep Trump off the ballot. And here's what it looks like. It is Norma Anderson, Michelle, Claudine, Krista, and others. These are the petitioners, the people suing. We have Jenna Griswold, who is being sued. So she's the Republican Secretary of State. So these people are trying to get the court to tell Jenna to throw Trump off the ballot. She's the Secretary of State, so she gets to decide that. So suing her, we want a declaration to keep Trump off. They're also suing the Colorado Republican Party, the committee, and Donald Trump. So Trump has filed several motions. In fact, there was a prior motion to dismiss that he's going to reference, but he really assembles the most recent arguments in this filing. So we'll go through this. But here he says here, Your Honor, in Colorado, this is Donald Trump's reply to the original. So he files, they respond, and then he replies in support of his special motion to dismiss. Let's get rid of this case. Now, we're going to talk about this for a bit here because there's about 8 to 12 pages, I think, of this slap stuff. But we've talked about this slap concept before. In fact, when Garrett Ziegler was here from MarcoPoloUSA.org, the authors of this incredible book, available now, you remember that we talked about slap lawsuits. And there are slap laws that are laws to basically stop strategic lawsuits against public participation. SLAP. Strategic lawsuits against public participation. So if somebody is engaging in running for office, for example, and somebody sues them to stop them from running, well, they're kind of stopping them from participating in the public, right? Or what if you're trying to speak? What if you're out there trying to do rallies or you're trying to make arguments in public about something and somebody says, well, you're sued for this and this and this, or you're breaching this, or, all just kind of nipping at the heels, just like barking away. But they're not really substantive lawsuits. They're just trying to kind of get you to shut up or to stop what you're doing. So there are laws that say, well, you can't do that stuff. And so Trump is making that argument here. They're saying, yo, I'm running for president. These people are trying to stop my participation in running for president. And so under Colorado, they're going to try to bring up this anti-slap statute, so to stop strategic lawsuits against public participation. So they say, Your Honor, and it looks like here they are in the district court, and they tell us, Your Honor, the people who are suing to keep Trump off the ballot, they make 3 arguments to say that Trump doesn't have anti-slap defenses. But they say those arguments fail. Here's why. President Donald Trump is the real party at interest in this case, and therefore he has standing to bring this motion to vindicate his rights to which they are trying to deprive from him. In fact, the Colorado Court of Appeals recently stated that the statute allows a person to file a special motion to dismiss under this statute. So it's kind of like a motion to dismiss, but even more advanced. It's special. So the court would not have included that parenthetical if it agreed with their arguments that they can only bring an anti-slap motion. So in other words, they're trying to make justification for why he can bring this motion to dismiss right now. And they give us some other case law explaining where they got this from. They say in this case, this person argued accordingly, and that here they rely on an older case that is not as applicable here. Nothing in this statute stops us from filing an anti-slap motion in a proceeding that is brought under the slap statutes. They say here in Colorado, the General Assembly passed this law called the anti-slap statute in 2019, passed other sections well before that. So we get the newest protections that come out most recently, and this is 2019. So this is fresh. So the new rules should supersede the old rules. So when it did that, Colorado, they presumed to know that election law controversies were governed by those statutes and that the anti-slap statute would have an impact on them. So this new anti-slap statute that Trump is using a defense under was created to supplant the older rules. Accordingly, the Congress, the Colorado state legislature, they had the opportunity to address how this would impact these various sections, and they could have exempted all of this, right? If they wanted those other rules to apply, they could have wrote it into the rules. They didn't. It chose not to do so. And second, the anti-SLAPP motion does not supplant this other section that they're relying on, and they want to use this other rule as the exclusive method for adjudicating these claims. But they say, in this case, the court can address the issues that we're bringing up here because the briefing and the hearing are going to be held prior to the hearing on their claims. And because we can harmonize these statutes, the anti-SLAPP statute takes precedence over the others, right? I know this is kind of technical, kind of boring stuff, but it's important. Petitioner's decision to file this strategic lawsuit against public participation, seeking to punish President Trump based on the exercise of his First Amendment. This is where we're getting to, right? The rules are in place. They're telling us which one is the most recent, most important, and they are bringing a lawsuit that is essentially covered by that law. Trump is only trying to exercise his First Amendment right. He's just trying to speak. And the Colorado laws do not strip him of his right to use this law, the SLAPP statutes, anti-SLAPP, to vindicate his constitutional rights. In fact, Congress in Colorado, the state legislature called the General Assembly, they declared that it is in the public interest to encourage participation in matters of public significance, and that this participation should not be chilled through abuse of the judicial process, which I would agree with. I think that we should have open and free speech about this stuff, but the government wants to continually gag him. They don't want Americans to be able to vote for Donald Trump. Are you kidding? They want him indicted or imprisoned, or obviously both, but they want him maybe more than that. They don't want him on the ballots so that there is not even a choice to vote for him. And if he's going to be on the ballots, well, then they're going to be demanding that people censor his name off the social media platforms lest they be infected with right-wing disinformation. And so they say, right, this is important stuff. You can't use the law. Like, there are frameworks to prevent using the law to stop people from participating in American democracy. But that is not the case anymore. Now we have the DOJ actively prosecuting people for participating in the process. Same with the FBI and others. So Congress, in fact, again in Colorado, we're at a state level, it passed the anti-SLAPP statute to do something, to encourage and to safeguard the constitutional rights of persons to petition, to speak freely, to associate freely, and to otherwise participate in the government to the maximum extent permitted by the law, which is what we would want now. But now, if you're in a bad text message group, you get convicted of January 6th insurrection and thrown in the gulags in DC for 18 years for being in a bad group and saying the government sucks. So petitioners want to punish President Trump for speaking about his belief that the 2020 election was marred by fraud, which we know it was, from ex-CIA who were, always CIA. The list goes on, to the FBI, to the media cover-ups, and the whole thing. And there was Democrat manipulation of the process to stack the deck against Trump. It is his right to make those claims, even if he's wrong. And you might say it's misguided and he's a fool for saying these things. And it's maybe even ill-advised, right? It's bad leadership, you might say. It doesn't matter. He can say whatever he wants. That's the whole point of free speech. Not that I agree with that, but I'm saying that's the point. We want people to be able to say things, and the things that are the most offensive, the things that you're not allowed to say, the things that everybody scolds you for, because you're not allowed to say it, that's what we want protected exactly. And many times that's what needs to be amplified. So petitioners cannot be permitted to strip him of his right to challenge their anti-free speech and anti-civil liberties lawsuit through an anti-SLAPP motion merely based on their preferred choice of procedure, especially when there's no conflict that exists. So they, Your Honor, they brought the lawsuit. They chose to bring this. And Colorado provides us a mechanism. So if they're trying to stop Trump from speaking, maybe they shouldn't have brought the lawsuit in the first place. And finally, Your Honor, petitioners claim that by that allowing an anti-SLAPP motion is antithetical to the speed, right? If you allow Trump to use this law to defend himself, then it's going to slow things down. But they say, but this court has scheduled both the anti-SLAPP briefing and a hearing in such a way to permit it to go forward either way expeditiously. There is more than sufficient time for this court to address the anti-SLAPP motion and the underlying issues, and for the appellate courts to review the decisions as well. We got a lot of time, okay, before the election starts. Now, they also note here in footnote 17, they say, indeed, by bringing this case under the election code, meaning these petitioners who are trying to remove Trump, they argue that Trump cannot receive the due process afforded every other defendant, such as discovery and a full and fair testing of the claims inherent in the system. I see what they're saying. So they're saying it's under the election code, and the election code is much tighter. All right. We remember covering many election cases here. I don't even know how many we covered, a lot. And there are very strict rules, timelines, deadlines. It's very quick. So they're saying here, by using that, they're trying to literally strip Trump of his rights. He wouldn't have discovery. He wouldn't have a full and fair testing of the claims. And they continue to seek to handcuff President Trump and his defense by arguing that he cannot challenge their claims by using an anti-SLAPP motion. So he's trying to bring in some more rules that are allowable under Colorado, but they're trying to take that away from him. And we remember this, right? We covered the Kari Lake trial here at length. I think we covered the whole dang trial, right? If I remember right, then we think we live streamed the whole thing. And it's all about timing and limitations, and they go very fast, and you can't seek certain things, and there's public protections about public records and blah, blah, blah. So Trump continues. He says, the petition that they're bringing, they're suing us. They say the petitioner's claims are not protected by the laws because it simply doesn't apply to this lawsuit. And one of the conceits, they argue, of the anti-Trump movement, one of the lies, is that they are acting for the benefits of the general public in their opposition to President Trump. We have heard this lie brought up many times. The public is interested in a speedy trial. Why? So that you can get a conviction in your court because that's what you want? Is that what we want? Do we just want a conviction? Is that the end game? Or do we want a free, fair trial where both sides get due process under the law and equal protection of the law in a fair jurisdiction with a jury of their peers? Because that's what I was taught was an important concept of American values. Those different things. But no, not anymore. Now, Judge Chutkan says, you don't even get to read the discovery. She's got 8 to 10 Washington monuments of copy paper stacked up that Trump can't look at. Or his attorneys can, but they got to go very, very fast, impossibly fast. We got a D.C. jury with 95% people who vote Democrat. And the list goes on, from Judge Chutkan refusing to recuse herself to all of the other pretrial motions that have already been denied, and there's going to be more of them. And they keep telling us that all of those justifications are for the benefit of the general public. I personally think that every one of those decisions is a detriment to the public. It is destroying the public's faith in the legitimacy of the judiciary, and it should. Same thing with the DOJ and the people who were involved in the investigation, like Jack Smith, Biden, and the entire institution of them. It is a travesty what they're doing. They are breaking the rules because they hate this defendant. That's it. And there are real consequences for that. So the general public is harmed by having a non-functional judicial system, which is really where we're going. Legitimately, okay? Because when we fast forward a couple years, this is going to continue. These 4 indictments against Trump are just the first salvo, right? If they're successful in taking him out, you think they're stopping? No. The rest of the Republicans are going to be prosecuted. And by the way, if the Republicans win, I expect them to prosecute the left. Otherwise, what good are they? And that's what this new pendulum is going to look like in this country, which is why a lot of people have concerns for the future. But here they continue. They say Section 3 is where we get into the 14th Amendment. Section 3 of the 14th Amendment, which is the insurrection clause, does not prohibit someone from running for office. It prohibits someone from holding office, and even then, only if Congress chooses not to lift the prohibition. It is not for the Secretary of State of Colorado to make this decision, as they say it is. The fact that Congress is responsible for this decision, as we've talked about. It's an insane extension. Okay, what limitation do you have? If you were to say, okay, left Democrats, you guys are so smart, so you get exactly what you want, right? All right. So Donald Trump is off the ballot because some knucklehead Secretary of State in some state somewhere just decided, I don't like Trump, and they just remove him. So that means that that's the new standard. So all Republicans have to do is win an elected office and come up with some bonehead reason that is justified and popular in their district to keep a Democrat off the ballot. Is that the general principle you want? That would be insane, right? It's not a functional standard, obviously. So how is that good for the public? It's not. It's a bad thing as a matter of public. So they say the fact is the matter is Congress is responsible. That's why they can make a resolution or a declaration, or they can impeach and convict in the Senate. They, Congress, the federal Congress, they have the ability to decide if someone should or should not be barred from holding office by voting to remove any disability. The premise of their logic, the people trying to remove Trump, is that it's the Secretary of State's obligation to determine if President Trump is prohibited from serving as the president based on the, quote, alleged insurrection, whatever they say. He insurrected. According to whom? Was he prosecuted and charged with an insurrection? No. So they say this is incorrect. That determination lies with Congress simply by the plain language of Section 3. And they say also, Your Honor, petitioners trying to remove Trump seek to benefit, they claim that they're trying to benefit the general public. Like, this is really helpful for all of us, wrecking the institution of American democracy by not even allowing us to vote for him. Okay, they're cheaters. They don't even want you to go and cast a ballot, so they want to just keep him off. And that's supposed to help us. But their position is actually opposed by a significant percentage of the population. According to a poll by PBS, apparently this one was published October 4th, so relatively recent, 47% of the public say that they would choose President Trump over President Biden. Look at that. And in fact, this is something we regularly do on our members-only morning shows, but we often take a look at the election betting odds to see what they have for us here, and look at this one as well. So according to these numbers, an accumulation, a conglomeration of the polls, Trump is up 34.8% to 32.6% as of this moment. And he is significantly in the lead to win the GOP nomination. So the numbers are pretty significant. They say it does not benefit the public to ban from the ballot a candidate that 47% of registered voters in America prefer. In fact, their argument essentially puts this court in the position of taking a political stance when it analyzes whether this element has been met by forcing it to decide if the public is better served by Trump being on the ballot or not being on the ballot. That is not this court's role. It's an insane thing to even think about, that they would be telling us who we can or cannot vote for. So petitioners argue that the Secretary of State is going to violate her duties by putting President Trump on the ballot. They actually are putting an insurrectionist on the ballot. That's why they need this court to clarify. And these new poll numbers, according to PBS, show how Biden and Trump are stuck in a dead heat. Oh, no. Trump's defense says, third, Your Honor, the removal people argue that they are not seeking, quote, any personal gain or relief other than relief sought for the public. They're doing it for you, America. Isn't that nice? As noted above, however, they seek to prohibit an individual supported by almost half the country from appearing on the ballot based on their political preference that he be not permitted to serve as the president again. This personal benefit to their political preferences outweighs the benefit to the public. They're obviously self-interested, especially considering that so many people want President Trump to be president again. They say, Your Honor, these individuals also are not addressing this element that they're not even trying to enforce an important right. What right of theirs is being violated by Trump being on the ballot? What has been breached? And therefore, they've met their burden. And so that ends the analysis right here. They haven't shown you specifically, was there free speech violated? Was there equal protection violated? Was their right to vote violated by Trump being put on the ballot? No, they're free to do everything they were free to do yesterday. But even if petitioners were to address this element, which they just conveniently ignored, they would fail to meet it. The statute says the action, if successful, it would enforce an important right affecting the public and would confer a significant benefit. So instead of addressing whether their petition to remove Trump, whether it would enforce an important right, how would the removal enforce that right? They instead change that language and they say, no, it's instead to vindicate public policy goals. A public policy goal is much different, isn't it, than an important right? When you say public policy goal might mean that everybody has access to a platform where they can have free speech. That might be nice, right? But that's not a right that everybody has access to a platform to have free speech or something like that. But they do have free speech, right? So it's a right that's a base layer versus a goal that might be a nice aspiration. So it's different, and the law is for the former. This is not what the statute requires. They can manipulate it however they want, but the petitioner's arguments fail. So regardless, they cite some other case law. And they say when you actually read what they wrote in that case law, you're going to see that that case doesn't apply to their argument. So despite the fact that they bear the burden of proof on this issue, the removal people do not identify which important public right affecting the public, that's us, that their petition seeks to enforce. How are we going to be benefited by them throwing Trump off the ballot? Indeed, they cannot do it because there is no right that they hold that they are seeking to enforce. And because they're not enforcing an important right that's important to the public, they fail to meet this element, and we're allowed to move forward on this matter, Your Honor. Now, that's all the slap stuff. Now we get into the real good stuff. This is the 14th Amendment argument. You can see this is Section 2, and this carries us on through the rest of the filing. And we get into some nice Civil War history and other things here, so let's get to it. They say, Your Honor, now that you know that the anti-slap stuff is settled, let me tell you the following. Trump is not disqualified under Section 3 of the 14th Amendment, period. Here's why. The removal people, they fail to show that Trump is disqualified, and they bear the burden on this prong to show that there is a reasonable likelihood that they would prevail. They failed to meet their burden, and therefore, this entire petition to try to keep him off the ballot, it's got to be dismissed. Got to go. Here's why. Section 3, the 14th Amendment, does not apply to President Trump. Okay? It just doesn't apply. The whole thing. Which is a big claim. They tell us here, as set forth in a previous filing, we've already explained that Section 3 does not apply to Trump, but let's explain why again. They say Section 3 disqualifies a person from holding office only if he, quote, previously took an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state. So you can see that. Did you see the word president in there anywhere? Says he previously took an oath. So we're going to pay close attention to this. What is that oath, right? And it also says verbatim from Section 3, member of Congress, officer of the United States, state legislature, or as an executive or judicial officer of any state. Now, they tell us clearly, easy to explain, because President Trump was never a congressman, never a state legislator, never a state officer, Section 3 only would apply if he was an officer of the United States. But we know the president is like a super user, root power for the entire Constitution, literally as defined. But as that term was used in Section 3, it did not cover the president. as an officer of the United States. Furthermore, Section 3 can disqualify someone only if his oath includes a promise to, quote, support the Constitution of the United States, footnote 32, all referencing us to the U.S. Constitution. They say, and the presidential oath does not. So let's break that down. First, Trump is not listed in any one of the subcategories as the president to which the 14th Amendment would apply. And the 14th Amendment mentions that anybody in that category, if you are properly articulated, you got to take an oath. So the question is, what does the president do? They say, we've previously said that the president is not an officer of the United States. And now let's explain why. They say the motion to dismiss also explains how Section 3 does not apply to all officers of the United States, but only to those who take an oath to support, right there, the Constitution of the United States. As explained, the presidential oath, which the framers of the 14th Amendment surely knew about when they wrote it, because they had presidents back then, requires the president to swear to do the following, quote, to preserve, protect, and defend. You see that? Preserve, protect, and defend is not the same as to support the Constitution. So he's not articulated in the list, and he's also not swearing an oath to support the Constitution. He's swearing to preserve, protect, and defend. Now, both oaths put a weighty burden on an oath taker, but however, because the framers chose to define the group of people subject to Section 3 by an oath to, quote, support the Constitution of the United States, but not an oath to preserve, protect, or defend the Constitution, the framers of the 14th Amendment never intended it to apply to the president. They carved it out. If they wanted it to apply to the president, they would have said so. If they wanted it to apply to everybody who took an oath, they would have said that. But they didn't. It was an oath to support the Constitution. Because you might have a different interpretation. Maybe support means something different than protect or defend or preserve. If they wanted to include the presidents in Section 3, they could have done it. They could have expanded the language in the 14th Amendment of which type of oath would bring an officer under the strictures of Section 3. They did not do it. And no numerical and no number of semantical arguments will change this simple fact. It's simple, Your Honor. Section 3 does not apply to President Trump. What do you think? They say petitioners also, they fail to meet the burden that they're likely to succeed because they're not going to be able to show that the violence on January 6th was, quote, an insurrection. Not going to be able to prove the facts on the ground. They say, Your Honor, these removal people, they fail to show that they have a likelihood of success in showing that the violence on J6 was in fact an insurrection, one, or that President Trump engaged in a purported insurrection. So, 14th Amendment in general doesn't apply to Trump, but let's say you say it does. There wasn't an insurrection even under the 14th. First, they improperly define insurrection. And second, they failed to show that the violence on that day was in fact an insurrection. And third, they failed to show that President Trump engaged in any purported insurrection or that he can be prosecuted or persecuted for his speech pursuant to the infamous Brandenburg Standard regarding incitement. What is incitement? What is not? A lot of reasons. So under the 14th, it doesn't apply to Trump. But here in this particular case, even if it did, it's not an insurrection. Maybe there was violence, but the violence itself wasn't an insurrection. And Trump didn't participate in that insurrection. And his speech that you claim led to the insurrection is not incitement language in the first place. So it would fail even the incitement standard before it could ever even meet the insurrection standard, right? You've got to incite people to do the insurrection. There has to be incitement to do something. And he fails that. So fail, 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 fail. I love it. Let's go through them each one by one, they say. Your Honor, first, the word insurrection is defined wrong by these dismissal removal people, cheaters. Insurrection is used in Section 3 of the 14th Amendment. It means literally taking up arms and waging war upon the United States. Footnote 35, their prior motion. Now, as set forth in September previously, the court must look to the definition of an insurrection. What does that mean? And in order to define that, we got to look back to the 14th Amendment. What did they mean when they wrote it? So we got to see how they understood that by the drafters of the 14th. Now, we want to note that it would make sense to define insurrection in the context of waging war. Why? Because the 14th Amendment and Section 3 were written, guess what? Right after the Civil War. Part of the Reconstruction era and the Reconstruction Amendment. It's 3 of them. Written with a specific context in mind. The Civil War, which the nation had just completed not 3 years previously when all this stuff was drafted. Now, we know that Joe Biden and Kamala and the rest of the left, they think J6 was a new civil war because they're kind of strange like that, and we'll get there. But they say that definition proposed by the petitioners proves too much. Their suggested definition would make any violent action taken by a group to hinder the implementation of a statute or a constitutional provision an insurrection, right? If we use their definition of an insurrection, which is basically anybody, I guess, interfering with Congress, with, by the way, Jamal Bowman did when he pulled the fire alarm for whatever reason. Not probably going to get charged on that one. But he insurrected Congress. There was a House in session. It was a critical budget continuing resolution vote. They were screaming at us about Ukraine. Everyone's going to die if you don't pass this budget. Jamal Bowman insurrects Congress. Boom. And we've seen it before. We saw the AIDS protesters were insurrecting McCarthy's office. It happened again last week or something. You know, there's always insurrections. So if the Democrats and this standard were allowed, everything would be an insurrection. But it's not a reasonable, workable standard. And they passed the word insurrection right after the Civil War. So it would create a disability to serve in any public office. Now, they're not interested in applying standards evenly. We know this. But if you just extrapolate it out, we're asking ourselves, what is the limiting principle? So any violent action would just automatically trigger the 14th Amendment and everybody could be disqualified, I guess, if they did something to incite it. So this definition would encompass much more overbroad than a true insurrection or a war upon the state. It would include a multitude of actions that should not bar a participant from serving in elected office. Indeed, if this were truly the definition of an insurrection, there would be convictions, in fact, for insurrection of the people who actually rioted that day. None have occurred to date. Nobody has been convicted of insurrection. Indeed, the punishment in Section 3 is radical. It prevents a person from ever holding public office again, absent congressional action. You got to overturn that. And so this type of drastic disability should only be reserved for the most heinous offenses, like literally waging war against the country. The definition proposed by the Trump removal people encompasses much larger group of people and would all suddenly be disabled from serving in public office. The definition set forth by Trump is more appropriate for this radical punishment. If you're waging war against the country, that's a different standard than challenging a rigged election. They say, Your Honor, in addition, the findings, the quote, findings of an insurrection by other entities and persons is irrelevant to whether this court should find that there was an insurrection. So, Your Honor, I know Liz Cheney put on a big book report for like 8 weeks, and we know you saw that, but you can't consider their opinions here. They cite another case. They say that case, United States versus Greathouse, where some other person, some other judge called it an insurrection. Their citation to that case does not stand for the proposition that the J6 violence was in fact an insurrection. Okay, the full quote from that case judge is, "The existence of a rebellion is a matter of public notoriety, and like matters of general and public concern to the whole country, may be taken notice of by judges and juries without the particular proof which is required of the other matters charged." All right, so I don't know where this case came from, but it doesn't look like it's a January 6th case. It's just saying generally, judges have the right to take judicial notice of other things. So like, it doesn't have to be a factual finding, Your Honor, but you saw what happened on January 6th. You can take notice of public notoriety rebellions and classify them however you want. The removal people are making that argument. Trump says, "This quotation does not stand for the proposition that statements by President Biden, for example, President Trump's opponent, carry any weight. If it did, any president could disable his opponent by pointing to a speech prior to a riot of his supporters, call it an insurrection because the supporters broke the law, and disable that opponent from serving," right? Obviously. You could just decide, which is literally what's happening right now. They're just calling him an insurrectionist and prosecuting him for it. Similarly, the J6 committee was designed to find as much fault with President Trump as possible. Nancy Pelosi, as we've talked about here, refused to seat Republican members recommended by the Republican leadership. We didn't get Jim Jordan on there. We got Adam Kinzinger. An unprecedented breach of protocol. And they created their fake committee and they did their fake show trial for all of the country to see. And the media lapped it up. This court should not accept such a politically and procedurally flawed document. So the statement that was made in Great House about taking notice of rebellion, that was made about the Civil War. There was a world of difference between the Civil War, which lasted, by the way, for 5 years and cost the lives of over 600,000 Americans, and the violence on January 6th, which was an hours-long riot that they returned to the same building and voted that same night. They didn't even like sweep for anthrax or anything. They're just like, bring them back in. Who cares? Maybe they did. I don't know. You know, my point is, it was just very fast. It was like, wow, okay, they just brought him back in? I thought there was like feces smeared on the walls and stuff. No, they just brought him right back in to vote. It was a matter of public notoriety that the nation had engaged in a civil war and that the Confederacy had engaged in an insurrection against the United States. It was 5 years, 600,000 dead. Here, there's much dispute about how to describe the violence on J6. Simply because some people have described the events as a, quote, insurrection does not prove the existence of an insurrection. And petitioners must do much more than present one side of this intense political controversy. Yeah, we'd like to have a say about it. So the quotation from, we'd like to say and have a vote, actually. Just let us vote for it. If we think Trump's an insurrectionist, we'll vote for the other guy. If we don't, we'll decide. They say this quotation from President Trump's attorney for the impeachment was taken out of context, and it does not mean what they claim it means, which is evidence from the fact, Your Honor, that they're lying to you. They chopped up the quotation to make it say something different. Here's the full quotation. They say this is what Mr. Van der Veen said when he was doing the impeachment proceedings representing Trump, saying, all of us during the impeachment trials, all of us, starting with my client, Trump, are deeply disturbed by the graphic videos of the Capitol attack that have been shown in recent days. The entire team condemned and have repeatedly condemned the violence and lawbreaking that occurred on January 6th in the strongest possible terms. We have advocated that everybody be found and punished to the maximum extent of the law. Yet the question before us is not whether there was a violent insurrection of the Capitol. On that point, everyone agrees. He said, in the context, the sentence on that point, everyone agrees, modifies the entire previous sentence and not the final clause, which is, yet the question before us is not whether there was a violent insurrection of the Capitol. He's arguing about whether the question exists, not whether about a violent insurrection. And so they just took that out to say that even Trump's lawyer agrees there was a violent insurrection when that's not what he's saying at all. They say, Your Honor, now despite their taking Trump out of context, the violence on January 6th was not an insurrection. They say that these removal people, they attempt to paint a lurid tale of the violence on January 6th, and they cite to the January 6th report that we know involved deleted terabytes of data, 1.5 terabytes of data deleted, because they didn't want the Republicans to see it. Why is that? However, the January 6th report is not admissible because it does not bear the indicia of reliability based on how it was drafted. Now, the judge, we'll see what they say about that. I completely agree. I think the whole thing is total sham. But, and the reason I say that is because there was only one-sided witnesses who were brought in. There was no cross-examination of any of these witnesses by an adverse party. In fact, there was not even an adverse party there. Cheney and Kinzinger were Republicans, so-called, but they were still on the side of the committee. So it's an unreliable, completely incredible report. Uncredible. Even if it were admissible, they say, and the courts were to view the purported evidence that it contains, it would still not even show that there was an insurrection. So the report's illegitimate, but if you look at it, it still is not going to prove what they say it proves. It would show violence, sure. It would show a riot, sure. But it would not show an insurrection. An insurrection is the making of war on the United States. The J6 rioters stormed the Capitol. They were inside for a few hours, and then they left. And ultimately, Congress counted the votes. Not a single piece of evidence shows that the rioters made war on the United States or tried to overthrow the government. In fact, petitioners can show not a single instance of anyone being shot by the rioters. Right, no, they shot the rioters. The rioters didn't do the shooting. The Capitol Hill police did. So petitioners cannot show a single instance of someone being stabbed by the rioters, which I know is a wild thing. And the only people who died at the riot, and because of the riots, were protesters. The sole police officer to die did so of natural causes, a stroke. Oh, man, and they get so mad when you bring this up. I brought this up on Twitter one time, X, sorry, Elon, and man, they flipped out. It was one of my best tweets. I said, by the way, Brian Sicknick something, and man, they lost it. All the left lost it. How dare you? We're going to sue you. I'm like, all right. So it's true. Even the Capitol Hill police admit it, and you can go look it up. So they're acknowledging it here. The sole police officer to die, Brian Sicknick. Rest in peace. I don't want anybody dying, especially of a stroke as a young man. But don't blame it on Trump's people or Trump and indict people for it. So they say President Trump, by the way, is also going to file next week in Colorado several motions in limine to prohibit inadmissible evidence that they seek to introduce, and he's going to object to some evidence as well. Ooh, that's curious. And yeah, here they're citing this article from NBC. Capitol Police Officer Brian Sicknick died of natural causes after the riot, says the medical examiner. Yep, sure did. So, even all that being said, they continue. President Trump, Your Honor, did not engage in an insurrection, nor did he incite one. Even if the riot on January 6th were to be considered an insurrection, so you see what they're doing? It's like the law doesn't even apply. But if it did, then this. And if that did, then this. But if this, then this. And all the way down. Even if the riot were considered an insurrection, there is no evidence that Trump engaged in it. The removal people do not point to any specific actions that Trump took other than simply speaking or not speaking. They cite a case law that says that, quote, engaging in an insurrection includes, quote, incitement through speech. But to qualify as engagement, a person must actually aid in the rebellion, citing another footnote. They say, yet again, petitioners cite to all manner of purported facts. They're just citing a bunch of stuff, but not one of the facts actually shows that President Trump physically engaged in an insurrection or urged people to riot or to storm the Capitol. They go back to the word fight. They say he said fight, like we're going to fight like hell. Recognizing this failing in their proof, they attempt to weave a web of prior statements that built up anger and resentment to the point that the rioters then invaded the Capitol. but not a single statement urged this, right? Trump never said it, but they're saying that he was talking about a rigged election all the time, and so that was a bad thing for them. And all of those different statements compiled together, stitched together into this fabric, created the incitement. They say they cited this, and it's redacted, I don't know what it is. Petitioner's citation to this, footnote 43, to argue that President Trump over time created an atmosphere that led to the January 6th violence. They say you can't use that either. All of these alleged bad acts, all of the problems you say, they were all speech. And as shown below, the Supreme Court has redacted sociological theories. Petitioners take 8 pages of their brief to recite statement after statement. They said Trump said this and Trump said that. But they do not mention a single action that Trump took other than speaking. And they can point to no statement that President Trump made that urged his supporters to do any violence or storm the Capitol. So then they, in fact, move on to his January 6th speech. They say different parts of the speech contained incitement. It was like coded language. But importantly, not a single one of those statements urged his followers to riot, and not a single one of those statements encouraged his supporters to violently storm the Capitol. In fact, as presented previously, he specifically called on his supporters to be peaceful and let their voices be heard. Voices. In order to get past these failings, the removal people make unsupported statements like, quote, the only way the mob could persuade the vice president to do anything was through intimidation and violence. The statement has no support in the record. They don't even cite it. It's just some angry law person. In fact, President Trump specifically told people at the rally that they should be peaceful and let their voices be heard. And a rally outside the Capitol presumably can be heard inside the Capitol and could be heard by Vice President Pence. People protest outside the Capitol all the time. So finally, because President Trump purportedly did nothing to stop the violence, they then allege that he engaged in the violence. You know how this one's going around now? Your silence is violence. It's all over the place. So Trump did nothing to stop the violence, therefore, he's a violent person. So no legal theory supports the finding, and petitioners' only citation to support the concept that President Trump's inaction amounted to engaging in an insurrection is to the Constitution provisions that he take care that the laws be faithfully executed and his oath. No legal theory supports inaction equals insurrection. They point to no case law, they point to no statute that defines anything that makes inaction as culpable either legally or constitutionally under the 14th Amendment. None of these actions included a call explicitly or implicitly to his supporters to riot, let alone to enter the Capitol to stop running the counting of the votes. And no amount of argumentation can change this simple fact. So, Trump, the laws don't apply to him. If they do apply to him, there wasn't an insurrection. If you think there was an insurrection, Trump was not involved in the insurrection itself. And here, the First Amendment prevents Trump from being disqualified under Section 3. So Trump's free speech overtakes the 14th Amendment's disqualification. Despite petitioners, the removal people, despite their attempts to twist his arguments to their favor, President Trump has not argued that Section 3 is unconstitutional. That's not what he's saying. Section 3 exists in tandem with the First Amendment, as it does with other parts of the Constitution. Just as a person's statements cannot be used against them unless that comports with the First Amendment, so is the government likewise prohibited from violating the 14th Amendment or the Fourth Amendment to obtain evidence to prove someone engaged in an insurrection. And Brandenburg and his progeny set forth the test for analyzing the speech. So Trump's speech has to hit this incitement standard for the speech protections to be violated. So let's talk about it. Now, recognizing the impact that Brandenburg has on this case, we're going to now talk about incitement. Okay, did Trump's speech? We know he didn't we know he wasn't physically there. So if speech is the only thing that caused him to be involved in this insurrection, he's just going down one argument after the other. All right, they say, sure, Trump actually wasn't involved there physically, but he said a bunch of things. Okay, so you say he incited? Well, let's look at the incitement test. So they try another path. They say, they know that Brandenburg is gonna dismiss that. They're gonna say if we apply the Brandenburg test, which is deciding whether something is incitement or not, they know they're going to lose, so they try to beat around it. They try another path to avoid it by suggesting that the First Amendment does not apply to the 14th Amendment Section 3 analysis, that you don't care about that. Claiming the First Amendment permits a number of speech regulations. So without citing to a single case that shows that the First Amendment does not apply to the 14th Amendment, they at most suggest that because courts have identified other limits on free speech, this court may exempt any analysis of Section 3 from First Amendment protections. Right? So when you analyze a legal issue, you've got to talk about how everything impacts each other. So you don't just analyze the 14th Amendment in isolation, siloed off from the rest of the Constitution. You got to include all of them. And so they're saying what the petitioners were arguing is you can kind of just get rid of it. We've got other limitations on First Amendment. We've got, true threats and incitement limitations and other repercussions if you defame some people, right? There are causes of action that not all speech is all protected, and with good reason. We don't want people to incite violence and stuff like that. So here, you got to consider all those things if you're just going to disqualify Trump from the presidency. So the argument fails for the simple reason that no court has ever made this finding, that the 14th Amendment just is ignored and is considered in isolation. Further, the First Amendment and Section 3 do not conflict. And this is an important nuance. Okay, Trump is not saying that the 14th Amendment is unconstitutional. That would be a big ask. That's like, pushing over the whole thing in one go. Can't do that. Instead, he's saying it just doesn't apply to me. So we're not going to undo 100 plus years of 14th Amendment jurisprudence. We're just going to say we're just going to pick him up and move him out of it. That's it. He's the president. Don't even have to worry about it. But now we go back to speech. So again, and we're in this world that they're saying it does apply. So speech that meets the Brandenburg test of incitement can be used to determine if someone is disqualified under Section 3. They say the analysis does not change if the government is the employer, as they suggest, but they provide no evidence or law that holds that the president is an employee for this purpose at all. And further, Section 3 also applies to non-federal government positions, and the federal government is not the employer of state officials. And here, the cases to which they cite do not stand for the proposition that Trump's speech is not protected by the First Amendment in the context of speaking about the election and fraud. So Trump's free speech trumps your 14th Amendment analysis where you try to limit the First Amendment implications. And wrapping up, they say President Trump and his speech did not encourage the commission of any crime. So they try to make another run at the First Amendment, trying to take it out. And they say that Brandenburg and the incitement analysis, which they know that they'll fail, they say it doesn't apply to Trump. We don't need to go down that road because they know they'll fail. Instead, they cite to another case. They say that the state, right, the state level has an interest, because again, we're in Colorado. The state may outlaw encouragement, inducement, or conspiracy to take violent action. But the court noted that the Supreme Court followed this logic to permit the prohibition of advocacy of concrete violent action, right? Something even maybe more aggressive than Brandenburg. Here, President Trump, under their standard, at no point advocated that his supporters take concrete action other than rallying and protesting, lawful activities. And he did not advocate that his supporters storm the Capitol and stop the counting of the votes. In other words, Trump's words do not fall into the exceptions to the First Amendment protections, and therefore, they provide no benefit to their claims. They continue, they say, finally, the removal people, they try to analyze the Brandenburg factors in a way that it would not prohibit this action, but they fail. Once again, by relying on the January 6th report, which is, as they say, inadmissible, the removal people claim that Trump, quote, summoned a mob, including armed extremists and conspiracy theorists, to Washington, D.C. on the day that Congress was to meet. He then told the same mob to march on the Capitol and to fight, in quotes. First, whether there were conspiracy theorists there is irrelevant, many of them proven right, as it is not unlawful nor insurrectionist to believe in conspiracies. So that is not even relevant, but thanks for including it. Sounds like it's kind of a personal attack. Now, otherwise, anyone who believed that Trump colluded with Russia during the 2016 election could be deemed an insurrectionist, which would basically mean the entire Democratic Party. And second, as explained in a special motion to dismiss, Trump's use of the term fight does not mean physical fight, but it's a metaphorical fight. Same words, actually less aggressive than many other things that other people have said. Like, I think many Democrats have said, fight like hell, get in their faces. Stuff like that. So, to get past Brandenburg's requirement of incitement to imminent action, petitioners continue to rely, the removal people, on their experts' analysis of President Trump's words over a 4-year period. And they suggest that Trump, listen to this, was grooming his supporters. Trump is grooming all of his voters to be little insurrectionists. However, that's not what Brandenburg requires. Even the theory of causation in this case is that this is not anywhere near close. Okay, the process of personality development is far from the temporal imminence that we need. We need actual incitement coming up. Imminent. So here, while they try to cite to another case to say that Trump was grooming people, okay, you know, grooming happens over a long period of time. We know what many of them on the left are doing to children around America these days. But it takes a long period of time. You really got to stretch that out. Is that incitement, which requires much more imminence? Like, it's happening now. Like, we're going here, we're going now, we're doing this right now. Because that's what's dangerous. If you're going to be saying we're planning on something that's going to be taking place in 2 months, that's not really that dangerous. So we might actually give you more free speech protections there. The imminence is what makes the dangerous speech, which is the incitement speech, dangerous. But they don't cite to a single federal court case to argue that Trump's slow words over a number of years could be an incitement to action. The fact is that court got it wrong because it found that while President Trump did not explicitly encourage the imminent use of violence, it was plausible because he implicitly did it. But in fact, nothing in President Trump's speech encouraged, either explicitly or implicitly, the crowd to storm the Capitol building. And as explained in the anti-SLAPP motion, Trump gave a political speech and he exhorted his followers to continue to the rally. His speech is like those of other politicians who give speeches to generate emotion and connection. And his references to Vice President Pence did not encourage violence, nor did his words to say fight. When you look at the speech in its full context, Trump was unambiguously urging his supporters to apply political pressure to the rally and to protest, not to violently storm the Capitol. No, he wasn't. The person who was doing that was Ray Epps, who got a slap on the wrist. Trump's additional arguments show he would prevail here, and Your Honor, for these reasons, this court should grant President Trump's motion to dismiss this case, signed here in the state of Colorado. Shout out to Jeffrey N. Blue and Joanna, the paralegal over there, doing good work. I really like this motion, and I like the logic. Did you see the logic of how he just took this and whittled it away from broad to little? Way out at the top. Jurisdiction doesn't even apply. The rules don't even apply. And whittled it all the way down. Number of reasons why Trump is not even included in the analysis. Then he says if it was considered an insurrection, he attacks the definitions, and then Trump's physical actions were not there, and then even if he was, he's protected by the First Amendment. Very, very solid filing, and a very good one. And I think the arguments are accurate. I think they're right. And I think Trump should not be removed from the ballots. But the question is, all you need is one judge. You need one Secretary of State in one of these states to do it. And the domino effect starts, the snowball starts rolling down the hill. gets bigger and maybe Trump gets booted off of some election ballot somewhere. We'll be here to cover, my friends. Thank you for joining us as we do. Thank you for liking this video and visiting robertgovea.com to check out our daily newsletter. You can sign up there so you make sure you get all this good stuff delivered to your inbox. Never miss an episode, and we'll see you on the next one. All right, my friends. Now we've got one segment left on the day, and this is with our old friend, Bob Menendez, Democrat senator from New Jersey. We've heard of him before. We read through the indictment the first time, some time ago. And let's see what he's got for us today. Because this was Gold Bar. Senator Menendez, Gold Bar Menendez from New Jersey, also known as the mini Joe Biden. He inherited Joe Biden's seat when Joe Biden left the Senate Foreign Relations Committee. And there's questions about his activities and really Joe Biden's activities because there's a lot of parallels between the two of them. And here Menendez was previously charged for having gold bars, allegedly from Egypt, but now he's got a new superseding indictment being charged with FARA violations, Foreign Agent Registration Act violations, saying that he was acting as a foreign agent for Egypt. Not good. We know that Joe Biden had a lot of questionable relationships with other countries. And so we're going to read through the highlights of the superseding indictment, get some reaction from some senators, including the very, very best and brightest, John Fetterman. But let's see what the White House is saying about this, because Menendez has a bunch of close connections with Joe Biden. In fact, Joe Biden was the person on this Senate committee that Menendez inherited. And so the White House got asked about this today.
To the Chairman Menendez thing, because in another realm, this would be a bigger effing deal.
Whoa! Did you hear that?
Successor to the president.
Did you hear what he just said? Let's go back to Menendez, because in another realm, this would be a big effing deal, is what he said. Did you hear that? Woo, getting spicy over there in the briefing room.
To the Chairman Menendez thing, because in another realm, this would be a bigger effing deal. A successor to the president as chairman of the Senate Foreign Relations Committee.
Well, he's no longer chairman.
No, but the president was once chairman.
Oh, I see what you're saying. Yes. I see. Yes. You're making that connection.
Yes,
got it. Successor. No, I got it.
Has been accused of being a foreign agent for Egypt, which, not for nothing, is involved in this situation right now, for that matter. Has the president been brought up to speed on this? If he has no comment today, can we see comment on whether he has any concerns that someone with that kind of a position may have been accused of it, and whether he should be running for re-election?
So we have always said it is a serious matter, right? We've always said that, and we'll continue to treat that as a serious matter. I just don't have anything else to share beyond any statements from the president. I just don't have anything outside of that. But of course, we see this as a serious matter.
In another realm, it's a pretty big effing deal, and I think he's right about that. This is a senator. Okay, listen, they had meltdowns. They said Trump was selling, secrets to the Saudis, and like they had a nuclear submarine silo popping up in a bathroom at Mar-a-Lago after Trump was breaking clavicles when he insurrected the Capitol. Like, they're nuts. They say that all this exists, but their own side is filled, as far as I'm concerned, with foreign agents, not only Menendez, but also the president's son called Hunter Biden. So they don't want to answer too much about it, but it is a big deal. And we're going to go through the document here in a minute, the new indictment. Here was another question from Karine, and here she says that you don't really, nothing from me.
Is the president okay with having a lawmaker who's accused of conspiring to act as an agent of a foreign government remain as a member of Congress?
The Admiral was just asked this question. I just don't have anything to say beyond what he shared.
This has been referring to Bob Menendez's superseding.
No, I know, and he was literally just asked this question. I'm just not going to say anymore to what he just added.
Nothing. So we've got that. We've also got this weird clip that I thought was a strange one. I wanted to share this one with you. Apparently, we've noticed a lot of things are going on in this world, but it's difficult to see the continuity with the pressure that has been placed on the Biden administration. I've seen that basically evaporate. And this guy is a Republican, and he's saying that we also should not be criticizing the Biden White House right now. This was a weird non sequitur. It's like think we can do a bunch of different things at the same time. I think we can also be concerned about what's happening in the Middle East and be concerned what's happening in America and be concerned what's happening with Joe Biden and all of these things. And this is a weird response from this guy. This guy's a Republican, retired Navy SEAL from Wisconsin. His name is Representative Derek Van Orden. And, this is as people are asking about Biden. Here's what he says.
But I want to speak to my Republican and Democrat colleagues here in Washington, D.C. This is not a time to attack the Biden administration. You know how adamantly I disagree with what they're doing, but as Republicans and Democrats, as legislators here in the United States of America, now is not the time to attack the Biden administration. Now is the time to stand with the United States of America. That means the executive branch and the military, to make sure that Israel understands that they have our unwavering support. So I'm calling on my Republican colleagues, our Democrat colleagues, let's get together, let's get the speakership done so that we can actually support Israel as they deserve it.
Yeah, speakership done. That's
What? Just do whatever we say. You don't need to even stop. Just all your other concerns about Biden administration and all the attacks that we were, investigating with all of the corruption. It's all, just forget about that, okay? It's all irrelevant. We need a speaker, and we need to focus on the Middle East, and just forget about all that other stuff. And man, we were hitting the panic button about this, like all of the Biden crime family investigations. We had good momentum here. We were talking about those every day. New letter, new letter, new letter, new subpoena, new subpoena, new subpoena. And now it's just like we have Republicans now coming out and saying, we'll just kind of hold off on everything so that we don't divert our attention. What? All right. So those are Republicans now. Now let's take a look at this superseding indictment so we can parse out some of this criminality that I still think is important. I think we should still be holding the Biden administration accountable. We can walk and chew gum at the same time. Here's 44 pages. It is the new one, the superseding indictment that came out. United States of America versus Robert Menendez and his wife, Nadine. He's going to give her a nickname, but I'll save that for another conversation. Here's the overview. Menendez, and we read through most of this, okay, so we're going to fast forward through this quickly, but we want to focus on the new charges, which is a Foreign Agents Registration Violations Act crime. Here they say Menendez, Democrat senator, senior senator from New Jersey. From 2018 to 2022, Menendez and his wife Nadine, they were engaged in all sorts of corrupt activities, including to benefit the Arab Republic of Egypt. Those bribes included cash, gold, payments towards a home mortgage, compensation for a low or no-show job. They got a luxury vehicle and other things. And a lot of these things were intended to benefit Egypt. In fact, they say that Menendez improperly advised and even pressured the United States Department of Agriculture for the purpose of protecting a business monopoly that was granted to Hannah by Egypt, right? A foreign government. It's wild. Menendez, the defendant, took another series of acts on behalf of Egypt, including on behalf of the Egyptian military, a U.S. senator, and intelligence officials. They communicated requests and directives from Egyptian officials, to Menendez. Agents executed search warrants at the home of Nadine and Robert, and they got court-authorized searches. They found fruits of their corrupt bribery scheme. And we remember some of these photos, just to hit the highlights again. Robert Menendez, look at that. Congressional Hispanic Caucus, 2,950s, 1,420s, and we don't know how many Hundo Benjamins are over here. But that looks like probably about $5,000, maybe $5,000 there. Sprayed out there. That's about probably the same. Now, we don't know what jacket this was. Senator Menendez right there. During the same court-authorized search of the home, agents also found furnishing, and they also found gold bars. Here you go. Relevant individuals for the gold bars. And we read all about those as well. And so you can see she ended up trying to sell those. And we see that this guy, Menendez, he held a leadership position, the same position that Joe Biden was on the Senate Foreign Relations Committee. He was the ranking member and then the chairman, and he had influence over, among other things, how the executive branch gave out foreign money. foreign military financing, and how that money flew to Egypt. And by virtue of his position as the senior senator, he had the ability to tell the president what to do and recommend who nominated and was served from New Jersey. And he said a bunch of things, right? He told us that he couldn't do this stuff, and then he ended up making phone calls to try to get people off of criminal charges. Here's some more stuff with Egypt. They did a search, and they found a bunch of text messages between Hannah and Nadine. So the Egyptian liaison and Nadine. Nadine deleted a bunch of these messages from her cell phone. But the search revealed thousands of text messages, many via an encrypted application, with Egyptian military and intelligence officials. So a U.S. senator was a played asset for Egyptian intelligence. Isn't it incredible? So Jose Uribe, another defendant, is a businessman there, and he was working in this as well. They tell us more about the statutes. Okay, so here's more about FARA. They say the Foreign Agents Registration Act is a federal registration and a disclosure statute that requires any person agreeing to act or acting in the United States as an agent of a foreign principal. So just think about Hunter Biden, right? Working for Burisma, working for the CEFC, the Chinese energy company, working for Romania, the list goes on and on. So to register with a U.S. attorney for the purpose of registering, so that they can monitor what you're doing, your political activities, whether you're consulting, public relations, and so on. We would like to know if we have foreign agents working in our country, and including if they're senators. So such registrations are made to the NSDFAR, gosh, these names, so that they can keep tabs on these people. Now, the purpose of FARA is to prevent covert influence by foreign principals like the Egyptians. Proper registration under the statute allows the government and the American people to evaluate the statements and the activities of the people who are registered. Among other things, it would reveal what they're doing, who they're working on behalf of, what they get, how much money, what political campaign contributions are being made, and others. Public officials, including members of Congress, are prohibited by law from agreeing to be or acting as foreign principals and agents under FARA. Illegal. Can't do it. At all times relevant to this, the Senate Ethics Manual, it was publicly available. He knew. It says, regardless of compensation in the manual, a public official may not act as an agent for someone else. That's why Joe Biden outsourced this to his family members. That's why Menendez outsourced this to his wife. But Menendez was just dumb. Okay, he got gold bars and cash. Hunter got wire transfers via LLCs, and he had more agents, apparently, inside the government than Menendez did. Or actually, I think what happened is they're just throwing Menendez away right now. I really think that. They're just tossing Menendez away just so it's one, it's 4-on-1. 4 Trump indictments plus the Michigan indictments for all those people, plus Rico's big fannies 91 counts, plus all of them. Let's get rid of a senator who's probably way too corrupt and has been found with gold bars. You know what I mean? They say the defendant, between 2020 and 2022, the senator, he made multiple requests for the DOJ to commence an investigation against another person for allegedly failing to register under FARA. Look at this. Wow. What a piece of work, this guy. Check this out. In particular, Menendez sent a letter to the head of the National Security Division. He wanted an investigation into another individual who had previously served as a member of Congress. Menendez, who is acting as a foreign agent, rats out another congressperson, who they won't tell us who that is, and sends a letter. Says this guy is failing to register as a foreign agent. He says, tattletaling on this other guy who's doing literally the same thing he's doing. It's all Congress. The act is clear that acting directly or indirectly in any capacity on behalf of a foreign principal triggers the requirement to register under FARA. So they've got this letter where this guy's explaining the law. Obviously, he doesn't know the law. Actually, I think this letter kind of supports him. Like the act is clear. He's saying, I've read, I mean, he knows it, obviously, but he would know that theoretically that person can't register. Oh, actually, he could. I'm sorry. He was a former register. He was a former member of Congress. He was not sitting. That's why. So, moreover, Menendez sent a second letter to the U.S. attorney reiterating that the former member of Congress be investigated for failing to register. So he's ratting, and I wonder who that was. Who do you think that was? In the second letter, Menendez said, if so-and-so, probably a Republican, carried out work that requires registration, it's imperative that the Justice Department ensure he is held to account. So he is asking the DOJ to investigate his former colleagues for doing the same things that he's doing. The first of these letters was posted on his public website for his Senate office, right? He's proud of it. And the second of these letters was also on the public website for the Senate Foreign Relations Committee. So, as a public official, they made clear Menendez was prohibited from serving as a foreign agent. And Nadine and the other defendants, they never registered either. In or about 2018, Nadine said that she was dating the senator. So, man, Nadine came in just and sniped this guy. She comes in, brings in Hannah. Nadine introduces Egyptian intelligence and military officials to the senator, and they want to create this corrupt agreement. These other dudes are involved. And they say, here's what's happening. By the way, at the background, at the start of this indictment, Egypt was among the largest recipients of U.S. military aid. They got over $1 billion per year. Yeah, and, I wonder what that's going to use for right now in that region. Very important region right now. Billion a year, billion a year, billion a year. Where's that going? What's that going to be used for? And in the form of direct government sales of military equipment, Egypt typically paid with foreign military financing, and the executive branch was involved in a lot of it. The State Department was involved. The State Department would honor holds placed. Okay, the State Department would interface with Senate Foreign Relations. In other words, the State Department would typically not proceed with a transfer without talking to the Senate Foreign Relations Committee. Menendez knew that, and he possessed substantial influence over Egypt. So for at least several years prior to 2018, despite its strategically important relationship with the U.S. and the Middle East, Egypt had often faced resistance in getting that money. State Department said it was withholding and so on. And so they came back in and they were getting Menendez to, I think, grease the skids, as it were. Ooh, we got photos. Now, these are new photos. We haven't seen these yet. Here we go. In or about 2018, Menendez met with an Egyptian military official and other officials at a meeting arranged by his girlfriend. Oh, isn't that cute? And her friend, Hannah. It's like a movie, man. Two, like, foreign agents. I think there is a TV show called Hannah. Is she a foreign agent in that show? Menendez allowed Nadine and Hannah to arrange and participate this meeting. He's like, hey, my new girlfriend's setting me up. And so they bring all these Egyptian officials from these Egyptian spies into his Senate office in Washington, D.C. And he's like, sure, I'll take a photo with you. Yeah, sure, sounds good. Stand right next to me. Gosh, it's like so obvious. Here, and they included discussions of foreign military financing aid. Here's a photograph taken during the meeting. Senator, so dumb. Here's Egyptian official 1. By the way, we got many photographs like this with Joe Biden, don't we? Many photos with Joe Biden standing right here. And you know who else is in the photos? Hunter, standing right there. So Menendez and Nadine, again, met with Hannah. Later the same day, Menendez sought from the State Department non-public information about the nationality of the persons serving in Egypt. The information was not classified, but it was deemed highly sensitive. Without telling his staff, Menendez gave that information to his girlfriend, and they sent it back over. And we talked a lot about a lot of this stuff. when they lifted, in the original indictment, we read through a lot of this, but here's just a quick, we'll hit some of the highlights and see if there's stuff new here. But they said shortly after dinner, Hannah, after dinner with Menendez, texted Egyptian official 1 that the ban on small arms and ammunition to Egypt has been lifted. That means sales can begin. That would include sniper rifles and other articles. That's cool. So, I mean, hopefully, Egypt is not involved in this, whatever this new conflict's going to be. If it turns out to be a global world war, I don't know what side Egypt's going to be on, quite frankly, but we'll see. Later that, and we just funded them to the tune of $1 billion a year in terms, including with small arms and other articles. It's pretty incredible what the U.S. is just giving out to the whole world, but whatever. Later that month, Nadine conveyed a request from Egyptian officials seeking in assistance editing and drafting a letter lobbying other U.S. senators to support Egypt. Multiple Egyptian military officials met with Menendez again to discuss this stuff. Menendez sent his girlfriend. He says, hey, tell Hannah, the Egyptian spy, I'm going to sign off on this sale to Egypt today. 46,000 120 millimeter target practice rounds and 10,000 rounds of tank ammunition, $99 million. Whatever. He says, note, he sends this to her, note, these tank rounds are for tanks they have had for many years. They are using these tanks in Sinai for the counter-terrorism campaign. I'm sure. So here they continue. Another date, 2019, they met with another Egyptian intelligence official, Egyptian official 3 at this time. They discussed a human rights matter. And this is interesting. The incident, they're talking about a 2015 airstrike. The Egyptian military used a U.S. manufactured Apache helicopter. The incident led to the citizens' injuries and the perception that certain members of Congress, that Egypt was not willing to provide fair compensation to that person. Shortly after the meeting, Menendez conducted a web search for the name of the American citizen. About a week later, using an encrypted message, Egyptian official texted Hannah in Arabic regarding this human rights matter. He says, if Menendez helped resolve this matter, he'll sit very comfortably. Hannah replied, orders, consider it done. Unbelievable. Egyptian official then texted Hannah of a statement from the American citizen's attorney. A few days later, Nadine, who in turn forwarded it to Menendez, Nadine then deleted her text messages about the matter. Wild. All right, so this was all about the Halal company. We read through a lot of that, and she got the money. She formed an LLC. He protects the monopoly. We've got more dinners. More Egyptian official dinners. There's the senator. And is that Nadine? Sitting next to him with Egyptian officials hanging out. And this is adding a little bit more meat to the bones. And let's see what else is here before we take a look at the new charge. We saw this photo last time in the prior indictment. Egyptian official number 5. Let's see, did they have the Christmas party photo in here? She was wearing a heck of a dress that day. And I'm sure the senator was, very happy with himself. Here's another photo, associate number 3. Man, they're having nice steak dinners out. Selling out America. Isn't that fun? So let's see where the charges are. And we'll wrap up this segment before we see what Fetterman has to say. So the first count, as we talked about originally, was conspiracy to commit bribery. And there were overt acts for that. Count 2, conspiracy to commit services fraud. Count 3, conspiracy to commit extortion. And count 4, conspiracy for a public official to act as a foreign agent. Boom. So here, from at least January 2018 to 2022, Menendez and others conspired to make him a foreign agent. In furtherance of this, we saw all the overt acts that we just talked about previously. They say they live in Englewood Cliffs, New Jersey. They've seized a bunch of money that they want forfeited. So here's all the stuff they took from Menendez. They took his residence, or they're asking for forfeiture of his residence in New Jersey. C-Class Mercedes-Benz, $480,000 of U.S. currency seized, so about $500,000 in cash. Whew, that's a lot. $80,000 in U.S. currency from a safety deposit box. And who keeps $500,000 cash at home? Gosh. 2 1-kilo gold bars seized from Englewood Cliffs. 11 1-ounce gold bars also seized from the residence. And any and all funds ending in 887 in the LLC, which is housed at a certain bank. They've also got One Vision Fitness suspension trainer. Oh man, what is that? A One Vision Fitness suspension trainer. Are they trying to get some exercise in? Oh, okay. Well, that's good. You know, I always encourage some good fitness. And this looks like, you know, this looks like an interesting thing here. So it's one of these machines, which is what they captured. Vision Fitness. That's a pretty nice little elliptical. Well, and I don't know what version they had, but it's good. You know, you definitely want to stay fit when you're carrying all those gold bars, don't you? You want to make sure that you're not getting too tired when you're lugging your $500,000 of cash around. So that's good. So they got all that stuff and 11 1-ounce gold bars, all seized. One Vision Fitness. Seeking forfeiture of that in the new indictment, signed off on by Damian Williams, the attorney out of the Southern District of New York, which is where we're at. So that is the superseding indictment. Mini Joe Biden is busted again for failing to register as a foreign agent. And I think that each one of those charges would have equally applied to Joe Biden and to Hunter Biden. And Joe was on the same committee that Menendez was. And Hunter was doing the same things that Nadine was. It's all the same story, just a different character. And they happen to be president. So one person, John Fetterman, is already asking and demanding that they throw his butt out. In fact, here's what he said. He said, John Fetterman on Thursday called on the Senate to expel Senator Bob Menendez. He said Senator Menendez should not be a U.S. Senator. He should have been gone a long time ago. It is time for every one of my colleagues in the Senate to join me in expelling Senator Menendez. We cannot have an alleged foreign agent in the United States Senate. He says this is not even a close call. And it's interesting when you hear something from Fetterman that seems, you know, like it makes sense because someone wrote it. But here's what he said. This is just a fun clip where he was on with whatever this dude's name is, and he's complaining about Congress. And just to be clear, I completely agree with him on this statement.
You all should need to know that America is not sending their best and brightest, to Washington, D.C.
Yes. True.
Like sometimes you literally just can't believe, these people are making the decisions that are, determining the government here. It's actually scary.
It is scary. You're right about that, John. Sometimes a broken clock is even right twice a day. And so that's John Fetterman. I happen to agree with him there. It is quite amazing that these are the people that we have in Congress. People like Joe Biden, who's now the president, people like Menendez, people like John Fetterman, sitting there, shocked as we are that he's in Congress as well. So we'll continue to cover, my friends. Thank you for checking out robertgovea.com. All these videos are turned into reports that are on there. You can also access all of these documents by signing up for our newsletter. You get access to the mind map. So everything you just saw is available. You can navigate and browse it around at robertgovea.com. We'll see you there. All right, my friends. Well, that is it for us on the day. We talked about mini Joe Biden, Senator Menendez, and his corruption and now new charges. We're very hopeful that we see something similar for Joe, but not going to hold our breath on that one. And we also had Donald Trump with, I think, a very good motion on the 14th Amendment. And I'm glad we spent the time on that because I was actually very pleased with how that turned out. I liked the structure of the argument. It felt very, some arguments are kind of scattershot, you know, they're all over the place. This was very logical, very well crafted. And so shout out to that lawyer who did that. But my friends, that is it for us on the day. And we are going to now jump into your comments and your questions. And thank you for becoming a member. And thank you for sending some donos in. That's how the show stays together. And we're grateful for them. And so let's see who we have joining us on this lovely day. And also, show note, tomorrow we're going to have an early morning show. So if you're getting out of here before we jump into the questions, it'll be an early morning show, probably 12 o'clock Eastern time is what I'm thinking, because I have an event in the afternoon that I'm going to go attend. So early morning show, probably 12 noon. Make sure you're subscribed. Make sure your notification bells are on, and we'll see what we have in store. Might not even have any news, but we'll do something tomorrow morning, my time, 12 noon, 9 p.m. Eastern time on the show. All right, let's see who we got in the house on this lovely day. And we got some good comments in the house. Revolutionary Bliss is joining us. And it's good to see you, Revolutionary Bliss. I'm glad that you are here, and thanks for becoming a supporter. And shout out to our supporters, YouTube supporters. Make sure you grab the Telegram link. It's in the community tab section on the YouTube channel, and we'll see you there, Revolutionary Bliss. We've got Dolphin Fan is the man, bringing in 10 new membos in the house. Dark in Snyder's here. We got Crystal H, Tornado Sunflower, Varank Gaming. We got Jace C, Danny Law, Jay Lee is here. Opposing Force, Scorpid Black Dragon is here, along with Napoleon, all in the house, joining us courtesy of our friend Dolphin Fan is the man in the house. And so we'll see you in the after party. We've got Dane Duard says no more dual citizens in Congress. Do we have a lot of them? That makes sense to me. I mean, we should have probably American citizens passing American laws, not dual loyalties. Here, this is just my opinion. Been a member for 9 months. Oh my gosh, it's a baby. Oh, it just came out crying. That's my... Oh. And so welcome aboard, newest member into the house, baby, and just my opinion. Congratulations. It's a healthy, beautiful baby boy. Says, yay, I reached baby status. It's good to see you. Just my opinion. 9 months, man. It's been cooking for some time. I'm glad you made it. And thanks for being here, my friend. A lot of fun. We've got this one from Angie. Says, been a member for 9 months. Hello, my friends. What's up, Angie? Thanks for being a member. And thanks for sticking around for 5 months, too. We're over halfway to a baby. We'll be there soon. And what's up, coffee, loves, hugs, flowers, high fives, U.S. of America. Love you back. Thank you, Angie, for being a great member. We've got Leonard's here. Says, why can Colbert and Kimmel use their shows every night to spread Democrat propaganda? Both shows are free public airwave programs. Well, they just control the companies that own the airwaves. I mean, I think that's really as simple as it is. You know, they own the companies that own the institutions, and I think they're on their way out, to be honest, Leonard. I think that they're old news. They're not that interesting. I don't think they have that many viewers anymore. They need like 35 writers to do a show. It's like, what do you need 30 writers to do a show for? We don't need any writers here. We just do it. So I don't know what's so complicated about it for them, but I don't know. You know, I think that they're on their way out, quite frankly. And they tried to do like a stupid podcast thing when their writers struck, and they sound like idiots. They sound like children. So, all right, this is Jameson in the house. Says, I've been covering the Colorado case for a while now, and I've done some videos on it. There are no cases really cited as part of the 14th claim. That's interesting. Yeah, so Jameson, you feel free to drop your channel. I know you're over on Rumble all the time. And so, my friends, if you want to check out another attorney who's covering some of this stuff, 2012 Jameson, I think is on Rumble. Maybe as the blind lawyer, is that right? If I remember correctly. Don't want to get it wrong, but feel free to drop that in, Jameson. I know you're doing some good work on this stuff. Says, Texas has a right to vote for Trump. Federal law has acknowledged a right to vote. Colorado plaintiffs are violating the 1983 claims. Counter lawsuit. But yeah, I mean, well, if Trump wins, like, what's going to be interesting is if Trump gets awarded attorney's fees on one of these, like if there's a penalty for trying to remove him. Unless there's a penalty for trying to remove him, they'll keep trying to do it. Jameson says, 10 U.S. Code Section 334 proves there was no insurrection. Taking us over to the U.S. Code and says, first, they didn't define insurrection. Insurrection Act of 1807. This was the precursor to the Civil War and the history of the 14th Amendment. See also 10 U.S. Code 331, 335 applies. From Jameson in the House. Good to see you, Jameson, and thanks for those good links and those good references. A Bad Poet says, how many times has Biden broken that oath? I can't even tell you. I think his whole family's been doing it for decades. For decades. They had a whole crime family that they've just been grifting for years. Jameson says, you need to read Counterman versus Colorado case. Sounds like a good one, 2012, Jameson. I appreciate the recommendation on that one. We'll see. And says, Insurrection Act of 1807 was a result of Aaron Burr, who wanted to raise an army and invade Mexico to become king. No insurrection occurred on January 6th. There's some very interesting history about United States and that time period. I mean, I think we had President James Polk. I think James Polk, didn't he also want to just take over Mexico? I think that was the president, if I'm remembering my history right. Like, he wanted to go all the way down to the Panama Canal and just take it. Like, America was in this, like, you know, expansionist kind of mentality. He's like, let's just go take it. And they kind of cut him off on that one, I think. So, very curious. Thanks for that, Jameson. Here, KR in your AZ. KR in your AZ became a supporter. Welcome aboard. KR in your AZ in the House as a supporter. Welcome aboard. We're glad to have you. And Jameson says the oath to support the law includes 10 U.S. Code 331, 335. The oath to support includes that. Here's our meme for the leaf blower guy, who we might hear tomorrow morning in our early morning show. We might hear leaf blower guy tomorrow morning. We'll see. Usually he comes at about 9 a.m. when we'll be live. A Bad Poets here says, did Menendez pay Biden for the seat? Good question. His MO, his modus operandi. Good question. I don't know. I don't know about that. Here, A Bad Poet also became a supporter over on YouTube. Good to see you, A Bad Poet, on the tubes. We'll see you in the after party. NY says, oh, lovely. We are like an auto dealership. We sell the weapons and then offer the financing. Yeah, and if you don't like the terms, you can just bribe the salesman. Isn't that nice? Hey, let me just throw you a gold bar. Give me a better deal. Okay, perfect. Randy Brandel's in the house. Says, great job explaining things, Rob. If Trump wins dismissal in Colorado, can this be used as evidence to dismiss J6 in D.C.? No, they're different jurisdictions, so neither one is binding on the other, just as a general principle. They're also different types of cases. So one is a criminal prosecution, the other, Trump is a defendant as a civil case. So they're not binding in any way on each other, and they're kind of too far. Like, there's not really evidence in one case that I think is going to be very useful in the other case. The other is a constitutional argument. Well, I mean, the same arguments are going to be applicable in both, but I don't think we're going to get anything out of... Trump is just defending himself against a constitutional claim here. So, like, it's not going to reveal anything that's going to be useful in the other case. I was going to say maybe if it was, maybe we'd see something from it, like if we got something in discovery or something, but we're not. These are just regular citizens who are suing him. It's not like we'd get anything out of it. So I really think it has no bearing. It's a great question, though. Finally, how did they let this detailed defense go public? Can they call it jury tampering and suppress it? That's a good question. So, well, it's a public case as a matter of public record. So, it's not sealed, and this is not at this moment involving anything that is allegedly classified or anything that should be sealed. And I think nobody's really asked for it to be sealed. So it's just public record. But I think that you're right about this. Like, this is what Jack Smith is trying to do. This is what the gag orders are about. This is why Trump is being limited from his jury, interview process, right? They're trying to limit what he can do and protect the jurors so that these types of arguments don't hit them. Like, they don't want more people to know about this, which is why we spend time going through all of it. So that, like, the arguments, when I think about going through documents, one thing I like to think of it as is that we're just translating it so that it's more publicly accessible so people can see it. I know most people will not read through a legal document, But I think that if more people saw what was inside of them, more people would know clearly that what they're doing to Trump is illegitimate. So that's part of the reason we try to make it more accessible, so that more not to tamper with the jurors, just to educate people about the legal system so that they know what's going on. And we're going to continue to do that. Good to see you, Randy. Thanks for the nice dono here today. You got Kevlar in the house. Thank you, Kevlar. Very nice dono over on YouTube. Gosh. And is also a member. Says, excellent job, Rob, as always. And thanks, Kevlar. I appreciate that. Today, kind of a quiet news day, so I'm glad we had something to dig into. Riley Leifson is a supporter. Amazing. Over on YouTube. Welcome aboard, Riley. Great to see you. Glad to have you. We got Bedford Badger also as a supporter. You gentlemen, make sure you grab the Telegram link on the community tab section so that we can see you in the after party. We got the good doctors over on Locals. Says, how come it's out of the Southern District in New York? New Jersey has its own district. That's a good question. And I think it's probably because a lot of the physical conduct happened inside the jurisdiction. And I don't know why. I'd have to look back at the original indictment, but it's some jurisdictional reason for it. Good to see you, Doc. We got Zulu says, what's up, Zulu? Bringing in 10 new members. Thank you, Zulu, for doing that, for filling out the membership. We love our members. We try to deliver for our members. We got Selrin coming in, Blackfoot Man coming in, Penn Halligan, Jim W, Brendan C. We got Linda G, Dr. Who Eric's here, Peter Jester, Dyer Gnomes, and Carol B, all coming in courtesy of our friend Zulu in the house. Good to see you, Zulu. And thanks for being here, my friend. Pinochet's Helicopter Tours says, so apparently Fetterman found a mirror. And Fetterman, yeah, he spoke some truth there. We really do wonder what the hell he's doing in Congress. And Fred Pedamonte says, walk and chew gum at the same time? What gum? Gum, I don't know. You can pick any type that you'd like, Fred. Whatever suits your little heart's desires. Gum it up, my friend. Now, let's say hello to our friends on X. And my friends, we started posting our segments on X. And so we appreciate you giving those some retweets and some boosts. If you like the content, don't feel obligated at all, of course. But we did start posting stuff. So, like, our regular stuff will be there. And hey, check this out, okay? So look, Trump prosecutor Big Fanny wins an order for Alex Jones and the RNC chair to appear in court. Will they testify? It's the full video, man. Cool, and it's working now. So like our full videos can be uploaded. So if you're following us, you want to watch it here, you want to comment, you want to like it, you want to exit, we'd love that. But today, we've got 6 viewers watching right now, and we're going to get this little thing going right here. Yeah. Oh, yeah. We're going to get that effect going here in a minute. It's going to take a while, so we'll skip over that. But who's joining us on the X? Any comments? Yes. O'Nelly's here. Says, I miss Nadine in that red dress. Oh, gosh. Great show once again. Thank you, Rob. Just one comment today. Very light day on the X. That's probably because we just have 4 viewers over there, but that's all right. So, my friends, that is it for us on the X. We are going to go over to watchingthewatchers.locals.com for our members only after party. Another reminder, we'll do an early show tomorrow. So about 12 o'clock noon Eastern time, 9 p.m. Arizona, 9 a.m. Arizona time is what we're shooting for. And we'll stick around and do our members only after party there tomorrow as well. But robertgovea.com to sign up for our daily newsletter. We'd love it if you signed up. We've got daily reports coming and some other fun stuff cooking as well. And then we've got the Eric's House fundraiser, which is coming up. And so tomorrow, we'll make sure we'll do it tomorrow and Saturday. So Friday and Saturday, we're going to do extra love and extra thank you to all of our supporters. And maybe on Monday too. We'll really hit it hard. So watchersupport.com if you want to support Eric's House to help their organization grow and help more people in need. And we're grateful for your support. Today, I want to say thanks to the mods and the meme smiths on the day. Vientikis Prime, K Beans in the house, Just Cause. We got Playing Hooky, our friend Ronnie. We got Zulu, Beyond Geostars, Zach Nichols, John Allen, Janek. We got Dog Digger, Donut Mind Me, and John McGarvey all modding down the fort for us. to keep things nice and orderly. We also want to say thanks to our friends Geegum Geegum, our meme smith extraordinaire, Nathan N810, and Sleepy Dog Lee over on the meme smith front. Grateful for all of your help and support. But my friends, that is it for us on the day. We are coming back tomorrow. It will be early, and I don't know what the show is going to be because there might not even be any news, but we'll figure it out. And so we'll be back here in the morning to do it all again. I do hope that you join us. It's going to be a lovely Friday, and we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well, and I'll see you right back here tomorrow. Bye-bye, everybody.